Thank you everyone for coming. My name is Ben Caldecott. I direct the Oxford Sustainable Finance Programme at the University of Oxford. Welcome to this report launch and reception focused on climate litigation and liability in Commonwealth common law jurisdictions. My organisation is one of the founders of CCLI, the Commonwealth Climate and Law Initiative, and I've been asked to give a brief introduction to CCLI and also to tell you a bit about the event today. I suspect that's because I am the one non-lawyer here, so I've been kind of given the task, and you won't hear from me very much after this. But before I continue, I just wanted to say some thank yous. The first is to funders of CCLI, in particular the KR Foundation, the Ivy Foundation and the Children's Investment Fund Foundation. I also want to thank the various partners of CCLI, in particular Accounting for Sustainability, Client Earth, the Centre for Environmental Rights, Ceres, Osgoode Hall Law School, the South African Institute of Chartered Accountants, the Peter A. Allard School of Law, and the Melbourne School of Law. I also want to thank some of our Advisory Council members, in particular those that are here today, Lord Carnwath, Nigel Brooke, who'll be chairing the panel session shortly, Paul Davies and Silk Goldberg, and also, of course, Clyde & Co. for hosting this event and providing the venue. The issues we're going to cover this evening are incredibly important and have been developing quite quickly over the last few years. In September 2015, you may have heard a speech by the Governor of the Bank of England, Mark Carney, and he highlighted how fiduciaries, including company directors and pension fund trustees, could be held liable for three things. Firstly, contributing to anthropogenic climate change. Secondly, not reasonably managing the risks associated with climate change. And thirdly, misleading investors about the business risks of climate change or failing to comply with legal reporting requirements. Now, legal actions have been developed in each of these three dimensions of liability. Other actions have been taken and new cases are being developed, and you'll probably hear about some of these shortly and in the Q&A. But in response to that interest from a central bank and a financial regulator, we launched CCLI that year at the Commonwealth Heads of Government meeting in Malta in November 2015. As you know, CHOGM, as it's called, what a great acronym, is happening this week in London. So it's appropriate that we're having this launch event at the subsequent Commonwealth Heads of Government meeting. We designed CCLI to be a research, education and outreach project, initially focused on 4 Commonwealth jurisdictions: Australia, Canada, South Africa and the UK. And the aim is that it would, when we hope to do this in a phase 2, expand to other Commonwealth jurisdictions. The 4 Commonwealth common law jurisdictions we're focused on account for 1/4 of global pension fund assets. Their stock exchanges account for 1/3 of the world's listed fossil fuel assets, and between them they have about 10% of the world's oil and coal reserves. So they're heavily exposed to the risk of fossil fuel assets becoming stranded as a result of policy and technology and other environmental risks. They also face significant risks from physical climate change, and whether that's droughts or flooding or heat waves, floods and so on, and you just have to think about some of the extreme weather events we're seeing in some of those jurisdictions. The drought in the Western Cape, for example, heat waves in Melbourne. I'm hearing about ice storms in Toronto from people from Canada yesterday, flooding in England and so on, the beast from the east. Company directors and fiduciaries in those countries, in these jurisdictions, are heavily exposed to both physical and transition climate-related risks. Moreover, because each of those jurisdictions operate a common law legal system, developments are obviously relevant to other jurisdictions in the Commonwealth, and also to non-Commonwealth common law jurisdictions, British Overseas Territories, British Crown dependencies, and all of those jurisdictions, many of them, have significant fossil fuel reserves and fossil fuel industries, major financial centres, and so one hypothesis that we have is that it's very hard to tackle climate change without action in those jurisdictions, and climate litigation and liability, and better understanding that, could significantly influence action on climate change in those countries and across the Commonwealth. So that's sort of some background about CCLI and what we're trying to do. So the event and today. So this is the culmination of more than 2 years' work. We're publishing today the first comprehensive legal assessments of the discharge of directors' duties in the climate context for our 4 focus countries. Each country legal paper is currently available to download from our website, which is commonwealthclimatelaw.org. And I think each individual paper is a significant contribution and has been authored by experts from each jurisdiction, some of which are here today. The papers have also been complemented by conferences. So we had one in Australia in August 2016 in Melbourne. We had 2 in Canada in October last year, and one in Vancouver and one in Toronto. We had 2 in South Africa in January of this year, one in Johannesburg, one in Cape Town, and we had the first one in the UK in Oxford in June 2016. There have also been some other outputs as well. You can get these from the website. We published some recommendations around the TCFD and TCFD implementation. So do download those papers, and hopefully you'll find them useful and share them and tweet about them. So we're gonna, just in terms of the agenda, so I'm gonna shut up shortly. I'm then gonna pass over to Lord Carnwath. We're then gonna have a panel discussion moderated by Nigel, as I said, and we have 4 panelists. Sarah Barker, Lord Carnwath will join the panel, Alice Garton from Client Earth, and Cynthia Williams from Osgood Hall. And I'll be perched over there, probably not saying very much, given what I said before about my legal experience. So a great pleasure to introduce the Right Honourable Lord Carnwath of Notting Hill. He became a Justice of the Supreme Court in April 2012. After studying law at Trinity College, Cambridge, he was called to the bar in 1968 and took the silk in 1985. He served as Attorney General to the Prince of Wales from 1988 to 1994. He was a judge of the Chancery Division from 1994 to 2002. He was also Chairman of the Law Commission and appointed to the Court of Appeal in 2002. So thank you so much for coming. Over to you.
Thank you very much. I've come here because I'm quite interested to learn about a subject which I think is enormously important. My own interest in this subject really goes back some years, my interest in environmental law, but I particularly got interested in the whole subject of climate change and the law, really in the run-up to the Paris negotiations of 2015, in the winter then, when it seemed to me that the role of the courts in relation to dealing with the climate, with whatever came out of Paris, was going to be fairly significant. And I organised a conference in London in September 2015 where we brought together sort of judges from a range of different countries, including a number of Commonwealth countries, just to sort of look at how the courts could deal with these issues in a practical way. I got a bit of flack at the time, funnily enough, for a judge getting involved in this. It's rather curious because in this country, I think, since the Climate Change Act, which passed with all party support, it hasn't really been seen as a political issue. But if you cross the Atlantic to the United States, the idea of a judge putting his head above the parapet and talking about climate change as a reality, it becomes a sort of deeply political issue. So that was quite a shock to find that I was being attacked in the American press, not so much in the English press, for having actually stuck my head out as an activist. But that was really about the sort of public the role of how the courts could enforce duties of governments. But at the same time, as has just been mentioned, the Governor of the Bank of England made a very important speech about the problem of stranded assets and the problems of directors' duties, and he drew attention to the potentially enormous losses from climate change action, which could make vast reserves of oil, coal and gas unburnable, and the importance of companies and pension trustees and so on really taking that sort of matter on board. The Paris negotiations in December 2015 were a remarkable achievement. I mean, I think one went into that not being very sure what would come out, but actually what came out was an astonishing degree of consensus among all the nations of the world. This was in Obama days when America was leading rather than sort of pulling back behind. But certainly that was the effect of the agreement. But also, I mean, I went to Paris and took part in the discussion there of the role of the courts. But I was particularly struck by the amount of interest there was from non-state actors, from authorities, but also corporations, businesses, and so on. Because I think everyone realised that there was a big sea change going on, and people were going to have to wake up to all this. Shortly after that, I was asked to give a talk by the Chancery Bar Association on some of the issues which we're considering here. And I must say, looking into it, the whole question of what the directors' duties and the trustees' duties were, I was surprised how little actually there was. There was 1 or 2 reports had been done. Ironically, the case law goes back to a case which was about fossil fuels, but rather different emphasis. There's a case called Cowan and Scargill in 1985. You're too young to remember that. I remember it at the time with Mr. Scargill, who was, of course, the Secretary General of the Miners' Union, brought this case to try and establish that the pension trustees shouldn't be allowed to invest in anything which was competing with coal. We now have a slightly different emphasis, but the result of what Mr. Justice McGarry decided then was that I'm afraid that the trustees, even of the pension fund, the coal pension fund, had to be guided by the interests of their beneficiaries rather than by particular interest in particular investments on other grounds. And that's sort of where the law has stood. But I think more recently a more flexible approach has come in. When I was at the Law Commission, actually, one of the issues we were looking at was the whole issue of company directors' duties. And this led in due course to the Companies Act of 2006, which did introduce a specific codification of directors' duties. And Section 172 of the Companies Act says that the director of a company must act in the way he considers would be most likely to promote the success of the company for the benefits of its members as a whole. But it goes on to say, in doing so, a director must have regard, amongst other matters, to the likely consequences of any decisions in the long term, and D, the impact of the company's operations on the community and the environment. Now, that was long before people were worrying about the sort of present issues of climate change in a big way, but certainly the idea that there was a broader responsibility to take account of the environment was a relatively novel idea then. And of course the Act doesn't really tell you how you're meant to balance that issue with the interests of the success of the company for the benefit of its members as a whole. But certainly it did give more flexibility for directors to take into account environmental factors. And there were similar developments in other areas of the law, pension trustees and so on. But I think the big sort of issue is, I mean, now it's obviously increasingly clear that the interests of your members of the company or the interests of the future beneficiaries of a trust fund will be very much involved in climate change issues if the assets are stranded eventually. So that is, there the issues come together. The more difficult issue is to what extent you can take into account these matters when they aren't of immediate concern to your members. The governor in the speech in September 2015 said this. He said, "We don't need an army of actuaries to tell us that the catastrophic impacts of climate change will be felt beyond the traditional horizons of most actors, imposing a cost on future generations that the current generation has no direct incentive to fix. In other words, once climate change becomes a defining issue for financial stability, it may already be too late." And although at the time he was criticised for expressing it in quite such strong terms, it's actually become increasingly apparent that the problem is making sure that we actually are addressing the long-term problems as well as the short-term issues. And I'll be very interested to hear. I mean, I think these reports are very timely because they do bring together the thinking on this and show, I think you'll find, will show us the way forward. The other aspect of this, which interests me particularly, is in my judicial role, is the Commonwealth emphasis. I've always been very interested in the development of the common law traditions, and this has been particularly so since I've been sitting in the Judicial Committee of the Privy Council. We're a slightly sort of pale reflection of the glory of the Privy Council in its glory days of 100 years ago, when the Judicial Committee of the Privy Council was hearing appeals from, well, I think all the countries represented here, and the principles laid down still apply. And of course, in issues like directors' duties and trustees' duties, there's a very common theme. A lot of the legislation in the Commonwealth countries goes back to UK precedents, as does much of the case law. We still see this. We get cases from countries ranging from, well, the Caribbean particularly. You get a lot of interesting issues about directors' duties from the Cayman Islands or the British Virgin Islands or Jersey and so on. And it's very interesting how these common themes, how we learn from each other. And of course we learn in turn from the Supreme Court of Canada, the High Court of Australia. And of course increasingly I find that I'm being invited to go and speak in countries like India, Pakistan, which also share these traditions and which are also facing up to the same sort of issues of climate change and the same problems. So I think it's very timely, this, and with the heads of Commonwealth governments meeting going on as we speak, I think it's a great initiative to bring this together. And so without any more ado, I will sit down and look forward to hearing from our speakers. Thank you very much.
So I'm going to segue into the second part of the presentation. Just a brief bit of context here. We're an international law firm, Clyde & Co, focused mainly on insurance. That's our main area. And we've been following climate change litigation around the world. There's a UN website actually that collects it all together, and it's growing rapidly. Obviously, disproportionate amount in the USA, but there's a lot in other countries. There's quite a few key cases to watch, including one in Germany against RWE. Today's focus is on one particular kind of exposure, of course, which is directors' liability, and this area, it looks like, is going to develop rapidly. It's of interest to us because any litigation, any liability has implications for insurance clients. And people who are writing business today may find themselves exposed to this. People who've written business in the past may also find themselves exposed. Some of the climate change litigation that has recently started will expose policies written back to 1965. So it's a historic problem and a current issue, a future issue. The reports, I would commend them to you. I didn't play any part in writing them, so I can speak objectively about them. They offer a broad and robust analysis of this area of law. They focus on 4 particular Commonwealth countries, including the UK, but I think they give a good impression of how the law lies in a wider range of common law countries. They've been thoroughly researched and the result of cross-disciplinary collaboration. So it's academics, private practice lawyers and public law. And then added to that, there's an advisory board who brought an even wider range of disciplines to bear. So these are really good, solid and reports with some quite striking findings. This what I think we'll find out today, the law already exists. There isn't going to be the need to invent new law here. The legal principles are well established. It's how they're going to be applied in the context of climate change. So let me introduce in a bit more detail the 3 panelists who haven't spoken yet. So, and in the order in which they're going to speak. Sarah Barker is Special Counsel at Minter Ellison in Australia. She's going to give an overview of the report's findings, first of all. Then Alice from Client Earth, who's at the end, I'm sure most people in the room know, but an NGO law firm. and she's the company and financial project leader. She'll put the UK context. And then Cynthia Williams, who's the Osler Chair in Business Law at Osgood Hall Law School, York University in Canada. That's quite a mouthful. But we'll offer both the Canadian and the US perspective. US is out of range, of course, of this Commonwealth reports, but I don't think we can avoid dealing with the USA in the climate change context. But she will, first of all, give the Canadian context. So, Sarah, if I can hand over to you.
Thank you. Talk amongst yourselves. G'day. I'm from Australia. And it is my great pleasure to be able to present on behalf of all 4 jurisdictional papers the overview of the findings from the Commonwealth Climate and Law Initiative. So what I'm going to talk to you about today is really the framework, because the framework that we found in relation to directors' duties across the Commonwealth was remarkably universal. And so that enables us actually to talk a lot more in generality and commonality than specifics. So what I'm going to do is first of all talk to you about, well, what is the Directors' Duties Framework that we're dealing with in relation to these 4 jurisdictions? Why is climate change an issue that is now relevant to commercial directors? And then very briefly give you highlights of our common findings in relation to those areas of law and those particular circumstances and facts where we believe there is the most likelihood of action being taken against corporate directors in this context. And I will preface these comments by saying I'm not an environmental lawyer. I'm a corporate lawyer. I've been a corporate lawyer for more than 2 decades. So I don't care about the environment or the community or ethics or anything like that. I care about money and I care about risk. And that's the lens through which I bring to these issues. So first of all, directors' duties across the Commonwealth. As I said, quite conveniently, corporate governance regimes, not just around in the Commonwealth, but also all around the world, are based on universal principles that derive from what it means to be a fiduciary. So a fiduciary is someone who owes their duties to a third party and undertakes to act for the benefit of that third party and to prioritise the interests of that third party above their own interests and the interest of any other third party. And corporate directors are fiduciaries of their company. What does it mean to be a fiduciary? Well, it comes from the Latin fiducia, which means faith and fidelity. Lawyers love Latin. And because all the corporate governance regimes all around the world are based in this concept of what it means to be a fiduciary and this concept of fidelity and faith and faithfulness, we have these universal underpinnings, these universal concepts of what it means to be a fiduciary. And there are 2 common elements. The first is trust and loyalty, because your principal, the entity to whom you owe your duties, has to have confidence that you are going to prioritise their interests above your own. Necessary but not sufficient, because they also need to know that you're not going to do a really bad job when you are prioritising their interests. So the second half of the fiduciary equation that we have is in relation to competence duties, so minimum standards of care and skill and diligence. So corporate governance laws all around the world are directed to giving flesh to one or both of these concepts around what fiduciaries need to do. So in relation to duties of trust and loyalty, they are given flesh through duties in relation to acting in good faith, in the best interests of the corporation for a proper purpose, to avoid conflicts of interest. So the first question that we looked at when we were considering, well, what are the duties of directors when it comes to climate change is, well, what are the best interests that directors have to prioritise, and is climate change consistent with those interests? And there, because we're all lawyers, I've put some sections in there so no one gets nervous that there's not enough law in this. So the second half of the equation, as I said, is in relation to competence. So these are actually non-fiduciary duties, but they are duties of the fiduciary. So a little bit of a subtle distinction there. So they're given force in concepts around due care and diligence, prudence, negligence or absence of negligence, and delict. So the second question that we need to look at is, well, what is the standard of due care and diligence that a director is held to? So if climate change is relevant to the best interests in their company, what do they have to do about it? And when is an omission going to be a contravention of that duty of due care and diligence? So there's a list of all the sections relevant there. So let's look at that first question. Is it in the best interests of a company to have regard to issues associated with climate change? Now, what the tragedy of the Horizon speech that Mark Carney gave is very well known. But what is less known was that sitting behind that speech was a very thick tome of a report that was drafted by the Prudential Regulation Authority that forms part of the Bank of England. A report on the impacts of climate change for the insurance sector. And in that report, the Bank of England characterised the three kinds of financial impact that climate change can have. The first are the physical impacts or the ecological impacts, which are the ones that we usually go straight to in our minds when we think about climate change. So extreme catastrophic impacts, floods, droughts, average temperature increases, and also more gradual onset impacts like sea level rise and things that happen gradually over a period of time. But that's only one subset of the financial impacts that climate change can have. The second is what we call economic transition risks. These are market-related risks that are as a consequence of market players responding to the threats posed by climate change. And there are three kinds of transition risk. First of all, policy and regulatory responses to climate change, like the Paris Agreement that has been referred to as the mother of all market signals, when you have 196 countries coming together and saying, we get that we need to all implement policies that are consistent with limiting global warming to no more than, to well below 2 degrees centigrade. And that is the policy trajectory that we are all going to follow. And we all agree that our policies are going to be consistent with a net zero emission economy in the second half of the century. Net zero emissions, if you think of how much coal and oil and gas we burn and how much meat we eat, because cows emit a lot of methane, that's a huge, huge change required in policy and regulation to make that happen. Then you've also got technological responses, which are market responses, market innovation in response to the threat of climate change. So things like developments in renewable energy technologies, battery storage, electric cars. These are not environmental impacts. They are market consequences of the threat of climate change. And then finally, we have stakeholder issues involved in the economic transition. So pressure on companies coming not only from their customers, because millennials are pretty damn passionate about this kind of stuff, but also at the other end of the investment supply chain, where you have got investors who are starting to say, this is concerning us. We are worried about the potential for this to impact on the value of our portfolios. So there's all those stakeholder pressures that are coming to bear on companies as well. And then finally, the third category of economic impact is liability consequences, my personal favourite topic, which is basically an outcome of a failure to manage both the physical risk exposures but also the economic transition risk exposures associated with climate change. Now, particularly with the addition of these economic transition risks, climate change is not an issue that we can just consider as a long-term thing anymore, that we can think about in 2050 or 2070 or 2100. It manifests very much within mainstream investment horizons over increasingly short terms. And who does it affect in the corporate community? Basically everyone. I talk about differentiated ubiquity. So it is ubiquitous. I think SASB, the Sustainability Accounting Standards Board in the US, did a study last year where it cut the US economy into 79 different sectors and reported that it was material in 74 out of those 79 sectors. So it has impacts right across the economy. But of course, different impacts, whether it's physical impacts or economic transition risks, depending on what kind of business you're in, where you're located, etc., etc. But it's no good saying, oh, we're not a coal company, so we don't have to think about it. So with the addition of these economic transition risks, where there are clearly market responses in train in relation to climate change, it means that this isn't just an environmental or moral issue anymore, because, you know, you obviously need something more than just the survival of the human race to get the attention of a lot of people. So what it means is that investors, that banks, financiers, credit rating agencies, not just NGOs, not just the World Wildlife Fund, have been starting to say at an accelerating rate, particularly in the last 2 years as a response to Paris, this is one of the key financial issues that we need to be concerned about. Even the World Economic Forum, that was their list of issues that concern them from 2016, the World Risk Report that they issue on the sidelines of Davos every year. In 2016, for the first time, a failure of climate change mitigation and adaptation was the #1 global economic risk that the World Economic Forum, that bastion of socialism and community care, came up with in terms of what its concerns were. And that's been reflected in the 2 reports since as well. Then we have the investors involved. So BlackRock, for example, the largest investor in the world, they've got about $6 trillion worth of assets under management. To put that in context, on average, BlackRock owns 7.8% of every listed company on the planet. That's how big they are. Vanguard up there isn't much smaller. So Schroders, State Street, the Norwegian Sovereign Wealth Fund, and now the credit ratings agencies, Standard & Poor's and Moody's, have said, yeah, we're going through our book and we are re-looking at everyone's credit ratings to see how susceptible companies, sovereigns, sub-sovereigns are to the risks associated with climate change. So, our first question, is it in the best interests of a company to have regard to climate change related risks? Hell yeah. Absolutely. Undeniably. It now is. So, we then looked at the duties of trust and loyalty in each of the 4 subject jurisdictions. And having a look at the risks associated with climate change and the shift in market views in relation to climate change, there was, as I say, remarkable universality in the conclusions that were reached in each of the 4 countries. So first of all, the conclusion that it is conceivable that a company director would be in breach of their duties of good faith, to act in the best interest of the company for a proper purpose, to promote the success of the members as a whole, in the words of section 172, or is in breach of their obligations to avoid conflicts of interest if they consciously disregard or are willfully blind to risks associated with climate change. And often case, that may arise where, for example, they have other interests or other associations externally that mean that they are not free in their own minds to be exercising independent judgment in the best interests of their company. So, for example, if they are a paid up and proud member of the American Petroleum Association, which means that they are duty bound to that organisation to maintain a particular line in relation to climate change. That may impact on their ability to exercise independent judgment in the best interests of their corporation. Similarly, if they were the chair of the World Wildlife Fund, you might argue the same way. Different outcome. Or similarly, if, for example, and this is an argument that I think Alice first developed, and I love it. If you were a director of an oil company and your remuneration depends on how much new reserve you discover or develop every year, that's a perverse incentive that might also put you in a position of conflict in relation to your ability to strategise around, well, what are the best interests of our organisation in relation to transitioning to a low-carbon economy. So that's the duty of loyalty. Conceivable breaches of duty there. Even more so, though, in relation to the second half of the duties, which is in relation to competence and attentiveness, so due care and diligence. Now, universally, the test there, the standard of care to which directors are held in each of our 4 jurisdictions, is a variation of the standard of conduct that a reasonable director acting in those circumstances would exercise. So that's got objective elements and subjective elements. Objectively, you're tested against the hypothetical reasonable director, but then in the subjective circumstances that you face. So you're a volunteer director on the board of an NGO and this is your first directorship role. Or are you a professional non-executive director sitting on the board of a listed corporation, in which case the expectations of you are a bit higher. Universally, the law in each of the 4 jurisdictions finds that this is not a passive obligation to exercise due care and diligence. There is professionalism and proactivity embodied in those concepts. And being a reasonable director does not mean average. So universally, all 4 of the papers referred to soft law instruments, like the Paris Agreement, like the recommendations of the G20 Financial Stability Board Task Force on Climate-Related Financial Disclosures, TCFD, which is the world's worst acronym, and the UNPRI, UNEP-FI report on fiduciary duty in the 21st century, and we have Paul from UNPRI here tonight, as being influential in determining, well, what would a reasonable director do? What standards, what extraneous materials should they be across if they're doing their job properly? The point I wanted to make here was actually about, well, what is the threshold for having to consider a risk? Is it material? So can you get away with saying, well, I'm exercising my duty of due care and diligence because I don't think this risk is material, therefore I don't need to think about it? No. How do you know if an issue is material to your business if you haven't thought about it in the first place? The threshold is whether or not an issue presents a foreseeable financial risk to your corporation. Then you need to exercise due care and diligence to determine, well, is it material? Is it material to our strategy? What are the risk management options associated with it, etc., etc. One point that all 4 of the reports were keen to emphasise was that in relation to due care and diligence, the law doesn't actually care what decision you make. It's concerned with the robustness of the process that lies under the decision. So the law doesn't care if you invest in coal, as long as you've got the robust process sitting under it, for example. So in all of these jurisdictions, there was a lot of emphasis around the fact that you've got to have the process in place to satisfy the due care and diligence provisions, because the courts are not keen to second guess the commercial wisdom of any decision. So the conclusions that were universal across all 4 of the reports were at a minimum, and I say at a minimum because these were the circumstances that were universally referred to in all 4 of the reports. There are jurisdictional differences where there are additional risks talked about. Directors may be at risk of breaching their duty of due care and diligence where they fail to think about climate change as an environmental issue. They just dismiss it. Yeah, it's not relevant to us. Aren't the scientists still thinking about that? Breach of your duty of due care and diligence. You have to educate yourself. So this is not something that, is a niche issue that hasn't been on the front page of the Wall Street Journal or the Financial Times. If they fail to adequately inform themselves, which can include information that they ought to know. So a failure, this is the known unknown. So Donald Rumsfeld was right. So you need to know that climate change is an issue because it's being talked about. You don't have to be an expert on it, but you then need to ask the question of the experts and seek independent advice where you need to. And it can also be a breach of the duty of due care and diligence if you fail to consider the advice that you're getting on point or blindly accept the conclusions of the advice that you're getting without turning your mind to it yourself. And universally, it's unlikely that the business judgment rule will assist directors here because of the fact that rule only applies to excuse breaches of the duty of due care and diligence where you are adequately informed and you rationally believe that the decision that you've made on the basis of that information is in the best interest of the company. And usually those breaches that I've talked about already are a product of failing to have informed yourself or a failure to turn your mind as to whether or not it's in the best interest of the company. The last duty that we covered was in relation to disclosure. There are no mandatory reporting frameworks in either of the 4 jurisdictions that specify things around climate change that need to be disclosed, other than in relation to some larger emissions. But in all jurisdictions, there are director obligations around misleading disclosure. The core obligation, particularly focusing on annual reports, is that there is a true and fair view of the financial position of a company presented and also of its financial prospects, because these reports are used by investors to make investment decisions. The threshold for the information that you need to disclose is materiality. You don't have to put a whole stack of immaterial information there. But what does materiality mean? Materiality means, is it decision useful for investors? Would a reasonable investor consider this information decision useful? And given the list that I went through before about what investors think about this stuff, you can't deny that the investors are interested in this. It's clearly material. All 4 papers indicated that soft law instruments like the TCFD are very influential in informing directors about, well, what information should we be putting in the annual reports in order to present a true and fair view of this material risk? So by default, the TCFD is almost becoming a bit of a legal standard. So the universal conclusions across the 4 reports were that it was most likely for directors to be engaging in misleading disclosure where the annual reports failed to discuss climate change as a material financial risk, failed to identify it as a risk to prospects. They overstate or understate their exposure to climate change or overstate their ability to manage it. If they misstate the value of their non-current assets, in particular on their balance sheet, because they haven't taken stranded asset risks into account, and we've already seen litigation to that effect against Exxon in the US. Or if they're selective in the demand forecasts that they use, that are overly optimistic in terms of business as usual, not taking into account any of the Paris Agreement obligations in terms of the potential for there to be demand for their fossil fuels going forwards. So is this likely that we're going to see litigation on this in any of the 4 jurisdictions? Well, litigation against any particular director is never really likely. Be a bit worried if litigation in relation to your board was likely, but is it credible? Absolutely. Absolutely credible. Of course, how exposed you are is going to depend on, well, A, the legal framework that you're operating under, procedural barriers that there might be to plaintiffs bringing a claim, the sector you're in, which country you're in, and also how how negligent you're being, how little attention you're paying to the issue. But there is a credible prospect of these claims. And because overwhelmingly in relation to claims against directors, they settle. They very rarely go to judgment. There is a lot of power in ostensibly unsuccessful litigation. It's used strategically by interest groups like Commonwealth in this area. So when I get a response from directors saying, oh yeah, but it's really unlikely that I'm going to get prosecuted on this. That's actually the wrong question. Is there a credible claim? Is it likely that a credible claim could be filed? And global litigation trends show us that this isn't just theoretical. It's happening already. It's happening in the US. It's happened in Australia. Client Earth is fomenting potential claims over here. And to me, where the risk crystallises is where you see the insurers starting to get nervous and starting to reconsider the terms of their D&O cover. They got burnt with cyber. They didn't anticipate cyber attack claims under the terms of their directors and officers policies. And they're starting to now reconsider those policies in the light of this potential exposure to climate-related risk. So certainly, as a director, you would be ill-advised to run the gauntlet on this on the basis that, no, it's going to suck. The next stage of the CCLI is an actionable framework, because we want to assist, or I certainly want to assist my clients in not being the ones who get sued. So as a result of that, we're now developing an actionable framework for them around, well, okay, what are the steps you can take to show that you are thinking about this in a diligent way? I just wanted to leave you as I sit down with a couple of quotes there, which I think are particularly relevant in this area. And I'll leave you to read them on the screen while I think, Alice, you're next. Thank you.
Thank you. So I'm conscious we started late, so I'm going to move quickly through so that we can have some panel discussion. First of all, Sarah's absolutely right. Client Earth is developing strategies. I'm not going to go into detail about those this evening, obviously. However, I do want to talk about just some specific issues that arise in the UK context, and particularly how they've been important for some of the work that we've done. First of all, the reasons set out above, the UK is a very relevant jurisdiction, although it may not have as much as significant coal resources. It does have a lot of companies listed in those sectors, and it also is a very large financial sector. That's right. We've already talked about Section 172, which is a very interesting and unique provision in the UK, because it is an enlightened shareholder principle, and it does actually explicitly refer to other stakeholders, which is one area that we did identify was different to the other jurisdictions. In saying that, we don't I wouldn't over-egg the importance of those other stakeholders in the context of the way Sarah has just outlined the argument, in that it is the core duty of directors to act in the best interests of companies. And in the context of climate risk as a financial issue, it applies to that first element or first limb of Section 172. The reason the Section 172 factors are very important for us, particularly, actually is linked more to the reporting duties. So in the Companies Act, we have Section 414C, which requires company directors in their strategic report to set out to inform members of the company and help them assess how the directors have performed their duties under Section 172. And therefore, if you look at the strategic report of these companies, and they do not talk about climate risk in the context of demand for their products, impact on the environment, long-term issues, so the long-term factors and trends which might affect the company model, then that is an indication that perhaps these directors are not exercising the necessary level or standard of due care, skill and diligence. Now, as a public interest law firm, we do not have standing to bring actions against company directors. That's the right of the shareholder. However, we are able to lodge referrals with the Financial Reporting Council. So these provisions actually enable public interest law firms to get at the heart of these issues and to raise the awareness with company directors and also financial regulators, the extent to which climate risk applies to these existing corporate governance duties. And we think that's an important aspect of the law in the UK. As I said, and Sarah alluded to, there are obviously significant procedural and evidential barriers to actually bringing directors' duties cases, but this should not impact on the fact that directors, it is a credible threat that these kinds of cases can be brought in the future, and decisions being made now are the ones that they may be liable for. So there was an interesting assessment of the UK's largest asset managers, a survey that was announced. At what point in time or how soon do we think we might see a significant revaluation of oil and gas companies? And the majority conclusion was in the next 5 years. So that's quite relevant as well. That's certainly within limitation periods. Now, in terms of the direction of travel, just a few points again about the UK, and this is relevant to how companies' directors' duties will be assessed because they evolve in light of market standard norms. We have seen the government endorse the TCFD recommendations. We have an ongoing consultation, the UK Corporate Governance Code at the moment, and we have proposed explicit reference to the TCFD in that Corporate Governance Code as a mechanism by which company directors can demonstrate that they are exercising due care, skill and diligence in assessing a reasonably foreseeable risk. So again, it's that process question that Sarah referred to. We have the Environment Audit Committee who's been incredibly active and is still looking, still has an open inquiry on green finance. They the chair of the committee has recently written to Gove and requested that each financial regulator produce an adaptation report under the Climate Change Act, which was actually the mechanism by which the Prudential Regulatory Authority produced its report a couple of years ago. So this is a really interesting development. If we see all the financial regulators produce similar reports about the impact of climate risk to those that they oversee, we will see some very significant steps, I believe, in the UK in the next couple of years. Just today, we have seen an independent review of the FRC announced. So the Financial Reporting Council is the key regulator for oversight of company reports and directors and auditors. And we have been raising for a couple of years now some concerns we have about the FRC, its accountability, its lack of transparency and its potential conflicts of interest. Those complaints or issues have been heard, and we have an inquiry that will be looking into those issues, and Clean Earth will be working very hard to ensure that climate risk is high on the agenda of the inquiry. So those are some of the developments in the UK, and I'll hand over to Cindy.
Thank you. All right, so let's not take too much longer because we want to hear from your questions. I am just going to emphasize one or two things that are different about Canada, other than the fact that it's way over an ocean and had ice storms 2 days ago in Toronto, which is horrible. I mean, normally you might have one in December, but not in April. First of all, Canada has an explicitly stakeholder-oriented definition of directors' fiduciary duties. In 2 Supreme Court of Canada cases, the Supreme Court has said very clearly the duties of directors are to the corporation and its stakeholders. And they have articulated that no one stakeholder group e.g. shareholders, have priority. So the stakeholders are listed. They're really the same stakeholders that are listed in Section 172 here in the UK. The shareholders are a stakeholder, but so are employees and customers and consumers and the community and even the environment. So how this, affects the law advice that lawyers give is an open sort of empirical question. Because although it is a stakeholder-oriented fiduciary duty, primarily it is shareholders who try to enforce the fiduciary duty in litigation, although it doesn't have to be. Because Canada also has very broad standing in its derivative litigation, in its derivative litigation statute. So a court could allow derivative litigation to enforce fiduciary duty brought by any proper complainant. So that this is not something that has yet been tested vis-a-vis climate change litigation, but for all of the reasons that Sarah articulated, it is not outside of the realm of possibility that there could be successful claims based on the fiduciary duty. And the second, we have quite recently, the Canadian Securities Administrators issued Staff Notice 51-354. And the staff notice, I think I'm one behind. Here we go. Sorry. Canada has not yet been able to develop a federal regulator for securities regulation. There are apparently constitutional problems on that. So regulation of securities in Canada is provincial and by the territories. But the provinces have mostly all come together in something called the Canadian Securities Administrators. And the Canadian Securities Administrators has representation from every province and territory, and therefore will from time to time issue national instruments, which are like treaties amongst all of the provinces. And then the provincial securities have to go back and get those treaty provisions enacted in their provincial securities laws. It's a clunky system, but there it is. So this year, after the TCFD came out with their report, the Canadian Securities Administrators started a study, and just last week came out with the results of their study. It's a year-long. They, first of all, reviewed the disclosure of 78 issuers across a number of different industry groups, and found that half of them were not doing anything other than boilerplate disclosure on climate change or no disclosure at all. They also did a survey of issuers and users, investors, and found a very significant gap between the perceptions of issuers. You know, this is a regulatory risk, if nothing else. It's not necessarily material, versus investors who said, you know, we are not getting the information that we need. And we need more information, in particular, about some of the core items that TCFD has suggested. The governance arrangements, the oversight, how is the risk of climate change being evaluated by your company? So what the CSA has agreed, and the different provinces will now take this back, is to educate issuers on climate change risk, which is a different kind of role of the CSA. It's going to be interesting to watch how that develops. Second, they have said that they are going to consider new disclosure requirements regarding climate change risk and board oversight and governance of climate change risk. And so this, I think, is regulatory speak for we will be looking into these new disclosure requirements. And then third, they're going to continue to monitor the quality of disclosure. So my observation, I'm a U.S. Citizen, U.S. trained lawyer. My observation of Canada, where I've lived for 5 years now, is that things move very deliberatively. There's a lot of process. There's a lot of careful thought that goes into things. But this project has started, and it's not going to just go away. So I think that Canada might actually have some good developments. Thank you.
So now we're going to get a panel discussion going. I'm going to put out a provocative question just to raise the temperature. But please think about questions that are prompted by what you've heard so far, and you can just put them to any member of the panel. So my provocative question would be, we've heard a lot about a direction of travel here, but it could be said that politically it's not all one way. So we've got the Paris Agreement was passed by 196 countries, but Trump has already said that he plans to pull the US out. Most countries haven't yet legislated Paris Agreement into their statute books. You've had some countries who put in a carbon tax but then pulled it back. And the carbon tax arrangements that exist perhaps aren't the most robust. So could a director legitimately say, well, it's all a bit uncertain, I'm going to wait and see?
No. On that, Nigel, and that's a response I get a lot from boards. I'd go back to that framework that the Bank of England promulgated in relation to, well, what are the financial risks associated with climate change? And policy and regulation was just one of those. There are technological risks that you can't ignore. There are shifts in stakeholder expectations that you cannot ignore. Mm-hmm. And with Trump pulling out, it was very interesting because the next day there was formed the We're Still In coalition, which now represents more than half of the US economy in terms of states, universities and companies who've said, we don't care what you say, we are still going to abide by these precepts. The universal response to that, I think, has been across the world, has been to double down on the need for action on it. So I think it's actually him announcing that they were going to pull out of the Paris Agreement has probably actually catalysed more action towards the Paris Agreement goals than anything else.
Okay.
Any questions? I think it's a question. We'll
right.
call him Stuart.
Let's throw it out the room.
Hi, my name is Kelly Clark, and I'm going to ask you a question that's more from a campaigner's perspective than from a legal perspective. But I wrote down, and I may have paraphrased it incorrectly, but the TCFD becomes a de facto law or a de facto guidance, if you will, for director's duty, which to me says that we're not very far away from being able to make a substantive case for the compliance to Paris being able to be made on an individual basis, particularly, or a liability for individuals, particularly CEOs and boards for systemic emitters, potentially the Climate Action 100 plus. Is that, from a legal perspective, a jump too far? Or is that something that through pressure from civil society organizations, et cetera, could be a reasonable reputational risk and therefore liability in the next few years? Maybe I didn't ask the question in a way a lawyer could answer it.
Yeah.
I'm not. Did you?
Yeah, I think that the Paris Agreement is one step removed. What the TCFD does is translate the Paris Agreement requirements into what does it mean for governance, what does it mean for strategy, what does it mean for risk management, what does it mean for disclosure. So I think because the Paris Agreement relates to what is government going to do,
Right.
you can't really hold companies accountable against that. But what you would say, and it actually would be very interesting to get your views on this, Lord Commonwealth, in terms of to what extent you do look at the external environment when you're looking at, well, what is reasonable in this context. It's an instrument that was developed by market stakeholders as their view of what is the information, what is the process that is necessary to present a true and fair view of this risk. So if you're not having regard to that as a director, then in my view, you're not acting reasonably.
So, Anton Hobley, CEO of the Carbon Tracker Initiative. First, I think, Nigel, response to your question, then a question off the back of that. This is already happening. I mean, you're right to identify the economic transition risk. So our analysis and the analysis of others like the Smith School show that a lot of money's already been lost. If you put your money into listed US coal equities 6 years ago, you lost almost all of that. Peabody, because their directors didn't understand the transition in China, made massive multi-billion investments in more capacity in Australia, sent them to Chapter 11. The European energy utilities over the last decade have lost 60 to 80% of their share value because they made the wrong decision and they went down a coal, nuclear gas route, not a renewables route. So what's the responsibility of those directors? And the best performing, to your point about the policy, the best performing energy commodity over the last 12 months has been the EU carbon allowance, which has gone up to something like 14, I think 13 or 14 euros now. We recently did some analysis that showed that 78% of US coal-fired generation now has to be subsidised by the US ratepayers to compete with the cleaner alternatives. In Europe, when we did our analysis on European coal-fired generation 6-7 months ago, 54% of European coal-fired generation is cash flow negative. It's now 66% because of that rise in carbon price. So my question, considering all of those lost financial losses that have already been suffered, you know, what liability might the directors of those companies now face?
Yeah. Those weren't necessarily in response to, the difficulty with that is to chop out the bit that is attributable to climate risk versus the bit that's attributable to the downturn in demand in China versus what's attributable to the fact that with the shale oil revolution in the US, it became cheaper to be generating electricity from gas rather than coal.
Solar or wind, which is also the cost of dropping.
Yeah, but that is bog standard 101, the kind of claim that you would be articulating against a director. Same with, say, for example, Kodak. Same thing. They missed digital. The directors got sued. Peabody, the trustee directors of the Peabody Pension Fund, have been sued by the beneficiaries, ironically for continuing to invest in Peabody stock as it was going down the toilet. So you're absolutely right. It's an issue that is here and now. It's not something that can be deferred to 2050. And if any of you here haven't read Carbon Tracker's work on stranded assets, I would absolutely commend it to you. It is world standard.
Just on that point, and I mean, I agree losses have already happened. As I said, public interest law firms don't have standards to bring these sorts of claims. So in your travels, if you come across shareholders who are interested, divert them our way.
Richard.
One brief comment on your provocative question, Nigel. Certainly in the litigation that we've been seeing recently, very little of the opposition to the relief sought has been on the grounds that the science is wrong or the policies are wrong. And so if you look at the Plan B challenge in this country and the Thompson case in New Zealand, that's not where the battleground's been. So
similarly, the recent US hearing.
So I don't think, I think that's almost a given in legal and evidential circles as opposed to political ones. The question really, perhaps, well, for panel as a whole, perhaps mainly Alice or perhaps Lord Commonwealth, it's corporate time horizons. One of the things that I think is interesting is the way you get a confluence of public international law principles and private law principles, and so, for example, intergenerational equity. I'm not sure, being a humble common lawyer, how trusts deal with and fiduciary deal with things on long horizons. maybe family trustees have to look to unborn generations, I don't know. But the real question is, how do you stop short-termism? People saying, let's ramp up the shareholder value over the next 5 years, drill, baby, drill, and future generations of shareholders can pick up the pieces.
Yeah, I mean, you've hit the nail on the head. The time horizons question is precisely what we were trying to get at in this research and understand, unpick our way through. I mean, if you're acting in the long-term best interests of a company, your duties are to present and future shareholders, actually. So you should be thinking both of long-term institutional investors, so those who have longer-term horizons, but also future shareholders of your company. So as a director, you should be thinking over longer periods, absolutely. Practically speaking, whether you can challenge that is something that this research project has been looking at. We do think remuneration policy, executive compensation schemes is one area where that, if there is a clear conflict between reserve replacement ratios and short-termism compared to the long-term best interests of the company, that's something that we think should be looked at. Yeah, so I suppose I agree. I think it is a very significant issue. The other reason that horizons come in, though, is, of course, that assessment of materiality when it comes to disclosure. And that's where we really see a problem. Although Section 172 does require long-term assessments in order to determine what goes into your reporting, we're seeing 1 to 3 year horizons. So climate risk is not appearing in the reports, and that's why the role of the regulators and the role of the TCFD is so important.
Although to that point, a lot of my clients are banks, and they say, yeah, fair enough, pension funds have got a 25, 30, 40-year time horizon. Most of the credit we write is 3 to 5 years in a commercial context. So, you know, we'll be long gone by the time those become stranded assets. To which my response is, okay, in 3 to 5 years, is that risk going to have crystallised? No. Is it going to become more acute? Yes. How are they going to refinance the loan? And if they can't refinance it, how are you going to get your money back? And so banks are starting to think about the implications for this in time horizons that are more extensive than, for example, what they lend. And as I said in my presentation, this is mainstream investment horizon stuff. If you're a car company and you're not thinking about the impact of electrification and hydrogen fuel cells on your business now...
Can I just, you posited a question to me. I'm not sure I'm the right person to answer, and I think what's been very interesting to see is how the long-term goals for government are being established, and you get the idea of intergenerational equity being sort of taken into account by the courts. And there's I was in Pakistan recently, and there the sort of courts have accepted that they have a sort of, the constitution in effect gives a right to people to have a clean environment, and that includes the right to insist on their governments enforcing climate change requirements and to put in effect their plan. So you get very proactive effects there. I think the interesting question which I was sort of looking for answers is how one converts that into the private sector. I'm very interested to see what Client Earth are going to be, how they're going to be doing that. And it's not ready for me to say how we all react if any of those cases find their way to the Supreme Court. But I do think it's, I mean, there's no doubt that, I mean, I think the disclosure requirement, someone was talking about the requirement to have a strategy report saying how you're dealing with it, I think is very important. So transparency, I'm sure, is a very important issue, because you actually put on paper what you're doing, then if it's full of holes, it doesn't carry water in that. And then, of course, shareholder power does become quite important. And there's going to be quite a lot of shareholders who do have interest in the future. The other point, I was rather interested in your test of what the director should be doing and how he should be informing himself. It didn't seem to apply to presidents of the United States, as far as we know yet. I'm still waiting for Donald Trump to tell us what exactly the rational basis is for what he's doing. But I mean, anyway, that's again not for me to comment on.
I think he just did.
Thanks. Peter Swank. The recent conference organised by Lady Rothschild on inclusive capitalism. There was very much a financial bent. One of the more salient and interesting speakers was a chap called Professor Robert Eccles of Harvard and Oxford. Chatham House rules prevent me from saying what he said, but it was highly amusing and very accurate.
Sounds like Bob.
His thing is integrated reporting, and ExxonMobil have been resisting this for some time. So he and a friend sat down and over 1 week, 40 hours, took public information that had been disclosed by Exxon, 10Ks, 10Qs, whatever, and produced an integrated report. Thus negating the argument from Exxon's lawyers that there would be some liability if they were to disclose their environmental and social risks and impacts. That's just an interesting thing that we're going to try and help in commercialise. So we can put any listed company into integrated reporting. So if you don't do it, we'll get some students to do it at Oxford. Not a problem.
Can I comment?
Shush. The question.
Oh, there's a question.
You can speak after this. The question I have is, Bob's other big thing is that he wants all listed companies in their annual reports to disclose significant audiences and materiality. In your respective jurisdictions, national jurisdictions, can you see that happening, or can you see how that can happen, and can we help you accelerate that happening?
So I'll have a crack at the first part of that, so Bob is actually on the advisory board of CCLI, so he's been in the loop. I do think that approach to automating integrated reporting is really quite problematic, actually. And I thought the whole point was that this was about company management engaging with issues and thinking about it. So if you've got, if you're just generating a report, that doesn't really help with that process, I don't think. And so I'm sort of a bit confused as to why Bob has latched onto it. But I haven't had that debate with him yet. But I look forward to having it with him. As to the second thing, Alice, others?
So the statement of audiences and materiality, this is stakeholders who are relevant to the company and time frames. Is that right?
He's coming at it from a financial theory perspective, and just from a legal perspective. I think Section 172 factors does already incorporate some of that, and that's why it's quite a unique provision. The extent to which it's being complied with is something Climate Earth is actively looking at, and it's not. And again, that's why we need the regulators to step in and start making some decisions, some public decisions on these inadequate strategic reports to demonstrate the fact we have a really good, strong law in Section 172, and it's drafted very well, and it's simply not being enforced.
Yeah, well, my academic work has been,
Or America.
America, yeah. My academic work has focused quite a bit on disclosure. And in fact, in the United States, we are a group of people, and petitioners are going to be bringing a petition to the Securities and Exchange Commission within a month, asking for expanded environmental, social, and governance disclosure. That having been said, there's really also at Harvard, where Bob Eccles was for many years, a project on transparency, Mary Graham's project, an Arkham phone. And what they have found by looking at 35 different transparency initiatives is it's only when disclosure is required and where there are identified users of the information feeding back that we can see the oft cited you manage what you measure in action. So to Ben's point, to require more disclosure on the theory that having this kind of disclosure is going to make managers pay more attention to things could work so long as the disclosure framework is well tailored to management. And I think that's what TCFD does quite well, right? Because it asks boards and managers to identify how are you identifying your risks? How are you governing your climate risk, at your board level? What targets have you identified, and what metrics are you using to figure out if you're reaching your targets? So it's all information that's very management centric, so I think it could be useful. Of course, disclosure is also excellently useful for providing the basis for litigation. Right? So in Canada, one of the few pieces of litigation, it's not litigation, but Kinder Morgan Canada was in the process of developing an IPO to fund its pipelines to the west, and Greenpeace brought a challenge to its documents to the securities commissioners on the basis that Kinder Morgan had used only one of the International Energy Association's scenarios for future oil demand, and had used the one scenario that was the most positive for Kinder Morgan, and had not used the other scenarios which showed China demand going down and electric cars being required as of 2025, that sort of thing. And it seems as if the Alberta Securities Commissioner actually listened to Greenpeace and did something, because Kinder Morgan restated their IPO document. But then again, of course, they did raise the money, and then very recently have said they're started to rethink this whole Western pipeline. So maybe this is a good case for directors' litigation, right? How much did you spend on this pipeline, which was going to obviously become stranded?
So,
So Sophie Evans with Willis Towers Watson on the insurance side. I have avoided becoming a Solvency II expert now for a while because it's stuff that my brain can't fathom, but I was really intrigued to see the word foreseeable in your presentation in the report, because the word foreseeable is part of the language that we use in the physical risk space in the insurance community to disclose our own physical risks, the risk of a 1 in 200 like Atlantic hurricane event hitting a Swiss Re's balance sheet. That's a requirement under Solvency II. It's a mandated disclosure requirement. And actually, because we use the same stress test analysis, it allows you to compare your Swiss Re's and your Munich Re's and your Hanover Re's and every other reinsurance company out there across a number of jurisdictions, many of which are in the Commonwealth. I wonder if there's anything under that now acceptable term of foreseeable, the way we can draw a line back to Section 172, saying the fact that we're doing physical risk analysis, we're doing physical stress tests on portfolios of our own asset portfolios, we can demonstrate we can demonstrate our fiduciary duty, because on the physical risk side we've got it sewn up. We know there's a great example, it's been happening for a number of years in the insurance community, and if that's anything that I would be really interested to see if there's anything that you guys have in your research where any of that has resonated from a physical risk kind of bucket side.
Sophie, did you want to say something here? Put you on the spot. Sorry. Sophie's authored an article and it's published in Nature on this.
Yeah, so there is a new branch of science that is potentially really relevant to the foreseeability of physical risk, particularly extreme weather events. Whereby the predictability and foreseeability of hurricanes, floods, droughts, range of events is improving rapidly. So that's certainly something for the insurance community to keep an eye on.
I think that the TCFD has tried to do that when it talks about the need for stress testing and scenario planning of your business plans, not just in relation to physical risks, but the economic transition risks. So how resilient is your business plan in a well below 2 degree world? So where economic transition risks are higher and more immediate, even though the physical risks are lower, and then at the other end of the spectrum, where there's no action, and so physical risks are much higher. The issue has been that the TCFD, I know they had a lot of debate about this, were reluctant to prescribe standards for that testing. And that is the next step. I think a lot of investors are frustrated because of the lack of comparability. So one of the issues that everyone is grappling with at the moment is, well, for comparability purposes, can we just have some standard metrics, even if the companies are also free to use whatever other metrics they want, but they have to give us the tests against the standard metrics so we can compare on some kind of objective basis. So I think having a look to what the insurance industry is doing would be really useful.
And I mean, we have started a review of annual reports, insurance company annual reports, both in relation to Strategic Companies Act, but also Solvency II. And would say, watch this space, completely agree that there does not seem to be an adequate reporting of foreseeable risks in those reports.
And of course, insurers have got two sides. They've got the risk side and they've got the asset side, and they have to pay attention on both parts. There was a question over.
I was just curious about whether or not there are any points of comparison about foreseeable risk, looking at the financial crisis in terms of banks that took on outsized risk, and as there were concerns about what the securitized market would do, whether there were any liabilities attached to banks. In the U.S., there's a whole range of litigation following that gave a good deal of discretion under the business judgment rule to directors and officers. And I was just curious as to whether or not in the UK or Commonwealth countries, how that particular notion of foreseeable risk, where that information would come from, and the directors and officers' liability attached to that.
I think the case in Australia is of most relevance.
Yeah, there were quite a few cases against directors arising out of the GFC. They all got squashed pretty quickly.
Global financial crisis. Yeah. Only Australians who call it GFC.
Oh, do we?
Yeah.
That's because we truncate everything. Because of the fact it was very quickly concluded that it was not something that was reasonably foreseeable.
It was not reasonable. Not
reasonable. It took everyone by surprise. You could not get a more diametrically opposed example in climate change. This is something that's been talked about for decades. It's something that certainly, I mean, you've had the UN FCCC, you've had the IPCC reports, and now you've had the Paris Agreement, you've got the TCFD framework. You cannot put your hand on it's front page of the papers. You can't put your hand on your heart and say, oh, no one could have foreseen this. Which leads to another really interesting, I think, area of litigation around force majeure clauses now in relation to climate change. What is an act of God now? Under climate change, it's really difficult to say that something wasn't foreseeable. So I think the Australian litigation coming out of the global financial crisis was in relation to more along the lines of misleading disclosure and negligence, where the investors were suing the credit ratings agencies and the derivative product issuers who were issuing what were rated as AAA credit rated instruments that were actually all backed by a dog basket of mortgage-backed securities in the US. And so they were successful in suing the instrument issuers and the credit rating agencies for being negligent in the way that they failed to take into account the risks to these instruments there. And then it was very interesting, after there was that decision in Australia, within a week, all the claims that were on foot against Standard & Poor's, for example, in the US settled. So, I mean, I think that's actually a really good example here of you only need one case, one jurisdiction for there to be a domino effect here, which obviously it didn't come out in a time that we've had with the presentations, but part of our work has been to identify, okay, well, which claim has got more chance of succeeding in which jurisdiction? Where is it harder? Where is it easier across the four?
Any more questions? I'm not going to pick on anyone.
Tell us about the next phase.
Yeah.
More countries, presumably. Diverse audience.
Well, in the first instance, we, in this phase, we still have to finalise with our advisory board and publish the actionable framework, which is a very practical outcomes of this work. We also want to then take the actionable framework to various other stakeholders, so financial regulators when they are assessing how companies might be applying or directors are complying with existing laws, they could use it as a best practice along with the TCFT. Auditors, it's relevant to auditors as well, investors. After that, we are then looking at a white paper, so policy recommendations related to, for example, issues around derivative claims and how difficult they are, and whether they really therefore serve the purpose that they're intended to, these provisions in the Companies Acts. Phase 2 will then be to look at other Commonwealth jurisdictions. Phase 2 for Client Earth will be to take some of the learnings and put them into practice in various jurisdictions. That will fall outside of the CCLI framework.
I think there's also, I mean, there are probably, I'm sure, points of law that the lawyers will want to examine and do more work on. But from my perspective, our this has always been about, what happens if these risks, how material are they for company directors and for investors, and what are the potential scale of losses under different scenarios, those sorts of questions. So we're quite keen to kind of do more work there. There's also related work in identifying companies and investment portfolios that might be particularly exposed to this kind of liability risk. So that's another avenue of work potentially.
Well, I hope you agreed that was fascinating and thought-provoking. Do download the papers. They're quite chunky, but well worth a read. The executive summary will be coming, won't it, for those who are shorter on time. And but there is a remarkable commonality, isn't there? But, as you say, yeah. And I think you'll probably find that in a range of other jurisdictions, as I said earlier on. There will be plenty of chances to carry on this dialogue. We're certainly going to be, as a law firm, we're doing a lot on climate change. There is, I think, a pretty clear direction of travel in all of this. And I think a theme that came out from this is, as well, is that the law does develop over time, but the basic precepts, common law precepts, don't change a great deal. They're just applied in a different way. But the law takes its cue from surrounding circumstances and public opinion and a range of other social and societal factors. And there is something in the air, if you like, that this isn't going to peak anytime soon. I'll be very interested to hear what Client Earth and other lobbyists are going to be doing in this field, particularly in the legal area. But anyway, can I ask you to thank the panel and speakers in the usual way?